it's very clear that you have this expertise in payments, and more specifically, this expertise in being able to, fight for the money when someone has actually taken something that they should not have taken. Patty, really enjoyed the interview today with Eugene Rome.
Hmm.
We did an interview with him not that long ago.
Yeah, it wasn't very long ago at all, was it? I thought so.
Yeah, but I was talking to him recently just about the challenge. I can't believe how many emails and messages I get that say things like my processor stole my residual,
Hmm.
or or
Hmm.
I had an ISO that split off from me and just took a bunch of my accounts, or just serious financial damage where there's going to
Right.
be litigation involved. And so today we really talk about how to really protect yourself, even in those situations where it's like seemingly too late, like it already something bad happened. What do you
Hmm.
do next, right? And so that was the subject that we talked about today. I thought it was insightful. Then I moved into questions from the field where I talked about overcoming common objections using vertical specific software. So, kind of this new reality we find ourselves in where we're selling point of sale, we're selling ISV solutions with integrated payments. How does that impact rebuttals of common
Right.
objections in sales? And then tell us about the insiders today, Patty.
Today I talk about the money that Visa alone is spending on cybersecurity to keep the payment system safe. And as James and I jokingly said at the end, what better thing than to let a third party that hasn't invested as much party money into the game. But I think, really what I'm saying here, Visa's spending billions, and that MasterCard, Amex are spending a lot of money too. So we're spending
Right.
probably hundreds of billions of dollars to keep this system safe. And I think
Right.
that's really important in any debate that we have over card fees.
Awesome. Well, before we dive into this interview, I do want to clarify, as I try to always do. In this case, Rome LLP, Eugene's law firm, they are a sponsor of myself, do different advertising and things with them. I brought them on as a sponsor because of this challenge I was facing of talking to people that are looking for, hey, who do I go to actually take these issues to court, help me get my money back? So that's what we're going to be talking about today. I'm really excited about that. So, with that being said, let's dive into this interview.
Let's do it.
Hey, everybody, I'm here today with Eugene Rome, founder and managing partner over at Rome LLP. How you doing today, Eugene?
Doing well. Thanks for having me, James.
Absolutely. Great to have you back. I know you were on the podcast a while ago, and we've had so many of our listeners that have reached out to me, and in some form or another, they've said, James, somebody stole my residuals. I'm no longer getting my money, or one of these types of issues. And we've spent a lot of time on the podcast talking about contract negotiations and things, but at the end of the day, a lot of times things just happen. And so we're going to talk about that. But before we dive into that today, Eugene, I'd love to get a little bit more of your background for those that maybe missed the first podcast. How did you end up getting involved in the payment space, and maybe give a little bit of context on kind of the work that you've done in our space?
Of course, happy to do it. And the reason I was smiling earlier is because the way you've been getting those calls about residuals disappearing, to
Yes.
use a euphemism, I've been getting those calls as well,
Right.
frequently, unfortunately. In terms of what we do, so we're an 8-person law firm, and our main emphasis is on litigation. That said, we do some transactional work in the payment space. I ended up in payments, I want to say about 18 years ago, kind of circumstantially. I was working for a guy who did payments law, and after I formed my own firm, had one case come, a second case, a third, fifth,
Right.
sixth, and we kind of went from there. We've certainly represented everyone in this space. When I say everyone, I mean within the hierarchy as opposed to every person. We've
Right.
represented everyone from referring agents to ISOs to risk-bearing ISOs to PSPs to MSPs, banks, and so forth. So we're very familiar with the entire space. And unlike a lot of people in this area, we've actually taken a lot of these cases to trial. We've won, and we've also taken foreign companies to trial here in the States. There are a lot of jurisdictional hooks
Sure.
that can pull a foreign payments company into US courts. And we've availed ourselves and our clients of those benefits. One thing comes to mind was a Philippine bank, which diverted, to put it mildly, about $1.5 million of our clients' money. And after some time, we went to trial, and it produced a $9 million verdict, $1.5 million in actual damages, and the jury saw fit to penalize him another $7.5 million for
Wow.
these actions. And it was a Philippine bank, and we ultimately, it went up on appeal, we won, and we collected.
Wow. It's great.
So the reason I bring that up is a lot of times the potential clients, they go, these guys stole my, whether it's reserves or these guys stole my residuals, or they took something, or they did something that is a violation of our dealings. But they go, but they're in Canada, or they are in the UK, or they're in Belgium, or they're in the Netherlands. So
Right.
what can we do? Well, the answer is sometimes not as much, given certain considerations, economics, size of the company. But other times you can do quite a bit. And
Yeah.
I think, first of all, my recommendation is just reach out to someone who understands it. You can reach
Right.
out to us or just reach out to someone else who gets it. But there are things you can do, because if you think about it, a lot of the payment transactions, irrespective of where the company sits, they go through US systems.
Right.
So whether it's Visa, MasterCard, and even though these card brands have foreign outposts, there's still enough local jurisdictional ties, often enough, where
Right.
you can establish some kind of a nexus.
Yeah. I love it. Okay.
And that was a much longer and elaborate way of answering your question
No, it's good.
for a legal overview.
Well, the thing I like about it is it's very clear that you have this expertise in payments, and more specifically, this expertise in being able to, fight for the money when someone has actually taken something that they should not have taken, right? And so that leads us into my first question. When an ISO especially falls into this situation, or an ISV, and they wake up one day and they're supposed to get their deposit of, 1.2 million in residual, or 100,000 in residual, or whatever it is, and they just don't get it. They don't get their money. And they get a notice, hey, we've held your residuals. Whatever the case might be. What is the cause of that? Like, in your experience, I know it's all over the map, but what are some common reasons or circumstances that arise where an upstream partner will decide to just stop paying residual income out?
So I think the reasons would be in something of a hierarchy. And look, I'm usually on the side of the person that gets ripped off, for lack of a better description.
Right.
So my point of view tends to be slanted. And so the first and foremost reason I would identify for that eventuality having come to pass is greed.
Yeah.
That's the reason.
Right.
There's usually not a cooperative reason for withholding someone's residuals.
Right.
So no, it's greed. It's because someone looked at the money that they have to pay someone else and said, you know what? I would feel a whole lot better if I did.
I love it. I love it. That's a very simple, very simple version of,
You know what?
but how
It's
do
that
they?
pitch that resonates well with jurors.
Yeah, and it's true. And
It's the starting point. And then
yeah,
you can get
it's
into the
true.
contractual relationships and
Right.
obligations that go there.
Right. But I guess the other way to put this question though is, how do the upstream partners justify it? Like, what's normally their kind of argument? Is it normally just like, oh, they got their hand caught in the cookie jar? Or I would imagine there's usually more of an elaborate, here's why we think we were able to hold on to this. Like, what does that usually come down to?
Well, it runs the gamut. I mean, from something on the more, I would say, potentially innocuous side, is when the ISO, and when we're talking about ISOs, just so we're clear, we're not talking about kind of a robust sales organization. We're talking about a guy who goes out and collects some applications from prospective merchants,
Right.
packages them, and actually delivers them to what I would deem as the ISO, the sales organization, and then
Right. Or even in an acquirer processor. Like a
there we
lot of the
go.
people I feel like too, they may have and it's so crazy because these terms in our industry are so kind of gray, but it's
Yeah,
like, yeah, somebody who's they're like just a sales organization, whether it's individual or maybe it's 20 reps, but you're just selling payment processing,
right.
and you've got these upstream partners that need to pay you in order for you to pay your reps. And yeah, that's where
So
you really
we're
run into problems.
so we're on the same page in terms of how we're defining ISO for
Right.
purposes of this
Right.
conversation. So an innocuous reason might be this, that the person referred one merchant that generates, say, $10,000 a month in residuals, but they may have three others where there's a loss on those accounts for whatever reason. And the contract is structured in a way where the losses can be offset with the positive obligation. To me, again, if the contract is clear, if
Right.
there's no games, if when the relationship's being negotiated, they tell them, listen, we're going to ding you for every bad merchant from
Right.
your positive flows. Okay, I mean, if it's properly drafted, all right, so long as no one's being tricked.
Right.
Now onto the more nefarious side, I suppose it would be, look, either we're just not going to pay him and see what happens. Let's see what he does. Maybe he won't do much. Or sometimes, and this is, kind of more malicious, you'll see the more upstream partners seeing how much money is to be made, especially if you cut out the middleman, because a lot of times those relationships are 70% goes to the ISO. So it's
Right.
a considerable amount of processing fees. They'll just get in touch directly with the merchant, tell them, look, this is business. We'll give you better rates. Cut your deal with or cut out your deal with the ISO and go direct. And it happens all the time. And sometimes the ISOs find out and sometimes they don't.
Right.
And that's kind of what it is. But, short of there being a legitimate reason set forth by a contract,
Right.
I don't see another reason. I mean, to me, greed would be the motivating factor. I don't know what the other reasons might be.
Yeah, what I was interesting, I was thinking about just my own experience in the last few months. I was thinking about one very, very large technology company that does payments, and they had a contract with one company, and then they decided that they wanted to switch and do processing with another company, which was their legal right, to do so. Well, the company they were with decided that they would withhold residuals because of one of the clauses about non-competition, and claiming that we need to see how this goes because you might be flipping accounts. It was one of these things where we're going to hold the money hostage as a negotiating tactic, So I've seen that a lot actually, where it's like, well, they really have no grounds for it, but they're saying, well, we think you might end up breaking one of the terms, so we'll just hold on to it while we do this negotiation to try to kind of keep them captive. I don't know if you've ever seen that kind of
I have
tactic.
not seen that particular turn. It seems rather aggressive. I think it also may be short-sighted,
Yeah.
especially if the aggrieved company pulls in a competent lawyer.
Right.
Because look, when funds are due, they have to be paid. If they're not paid, it is a breach of contract.
Right.
And in certain circumstances, it could also be conversion. Theft of money in the legal context is a little bit different than you would use the term colloquially. Colloquially, you see a guy reaching into someone's purse, pulling out their
Right.
wallet, under the cover of night. The way conversion works in civil litigation, at least, is it's just when you dispossess someone of funds to which they're entitled. And what's critical is intent is not even a factor. So someone doesn't need to intentionally try and steal the person's money. They can just be holding the money and not paying it to that person, even if they in their heart of hearts believe that the person's not owed it, or the company in that case. They're
Doesn't matter.
still potentially liable for conversion. And this happens to banks all the time, acquirers, where the ISO is telling the acquirer, look, don't release the reserves. There's risk, there's risk, there's risk, because they're hoping the merchant will simply go away. Then they tell the acquirer, look, we've struck a deal with the merchant. It's all good. Pay the funds out to us.
Yeah.
Apart from the obvious ethical and just other legal issues there, but the bank would be liable. Even though the bank could say, look, we're acting in good faith. We've known this ISO for years. We've worked with them. We certainly didn't get a cent of that money. Nonetheless, they're liable. If you're holding on to property that belongs to someone else and you transfer it, not to its rightful owner, but to a third party, or even if you withhold it and don't pay it over, that's conversion. The reason I bring up conversion is because it is a tort. So there's exposure for punitive damages, and under California's penal code, I think it's section 496A, if memory serves, but where there's intentional acts of of conversion in a civil context, even though it's a penal code statute, the damages are trebled. So, and you might get attorney fees. So you go 3x on the amount withheld. So going back to your question, the strategy that you've described to hold money back to offset a potential violation, just thinking about this on the fly, also the question is, well, how much are you holding? Because even if there is some kind of an argument to be crafted, the question I would be asking, certainly in deposition, if when we get there, is, well, at that time that you decided to hold the money, how did you calculate your losses, where your potential losses from this yet unpursued activity? where you think, okay, we need to hold all the reserves or all of the residuals
Right.
because this is how much money this person could potentially cause us as at a loss.
Right.
Look, I don't think a judge would buy that. The jury would certainly
Yeah,
not buy it.
they didn't. It ended up ending very rapidly. In that case, it was yeah. What one other one I wanted to throw out there, just as we're kind of setting the context to give people an idea of when these types of things occur. One of the other most common ones I've seen can actually happen the other direction, where we'll have a an ISO. They've got again 20, 30, 40 salespeople, right? And they train them, they give them leads, they have a contract with these people that hey, these accounts are our accounts. They pay them an upfront bonus, even that sort of thing. Well, then they'll have, 3 of those 20 reps decide, you know what, I think we're going to break off and we're going to go start our own thing. And we had, 300 mids that we did with this one. We'll start by flipping all those. Right. And so now we have that ISO and it's like they'll steal a bunch. So I don't know if that's something that, what your thoughts are on that, but that's another kind of real common thing in our industry as well that can really be very, it can be a portfolio that's worth several $1,000,000 that all of a sudden just it evaporates,
Yeah. So let me walk you through how I would analyze it. And again, you're
Yeah.
throwing these out, so I have to do it
Yeah,
on the
I like
All
it. It's
right,
good. Yeah.
I'll tell you. So the company, the initial company from which these 3 potential employees departed,
Right.
you would think there would be some kind of an agreement with the employees saying, look, a lot of this is confidential, you're supposed to keep it confidential and so forth. And then you get into whether or not appropriate methods were maintained to keep the confidentiality of the current customer list, the prospective customer list, and so forth. And the reason that's important is because the analysis goes, look, does the identity of the existing customers and the potential customers, does it rise to the protections afforded, and I'm speaking as to California law right now, under trade secret law in
Mm,
California? Customer lists certainly are subject to trade secret protections. And the question becomes is, well, are these unique customers? A lot of times they are,
yeah.
because you're looking, someone would be targeting businesses that are either in the high risk cannabis vertical or high risk nutra vertical that do 10 to 20 million a month. So in other words, you would not get trade secret protection if all you're doing is you grab well, back in the day when we had the yellow pages, but now
Right.
something more electronic, and you just start calling all the A's. Do you guys need
Right.
processing? That wouldn't fly.
Right.
But if you really develop this list through a lot of work, where you've identified a specific kind of a client, a merchant, and I think that would warrant a trade secret protection in the right circumstances. If
Right.
the contracts were properly written, if computers had, password protections, if access was only delegated to people that really needed to see it, as opposed to the whole company.
Right.
Those are the typical factors that the courts evaluate. So then potentially you could sue these departing sales reps who are trying to
Yeah.
switch everyone over for trade secret misappropriation.
Yeah.
And you can actually enjoin, which is a legal word for stop, through a court order, this conduct. And this
Yeah.
happens routinely in business because,
Yes.
a lot of times the merchant list is the lifeblood of
Right.
a business.
Right.
Without that, you have a few computers, some desks, and that's it.
Right. Yeah.
So the courts recognize that and they uphold those protections. Now, keep in mind, you have to balance some of this with California's very strong protections afforded to employees, where it says, look, you cannot stop an employee from just competing. Now, the
Right.
competition has to be fair, but you
Right.
can't say you can't work for the next 3 years if you leave here. The
Right.
California court would simply not uphold that.
Right.
So, for one thing, a lot of times you get lawyers that are aggressive but not savvy. So they create these really restrictive contracts. And the person that hires them, the company, looks at them and goes, great, these people can't do anything when they leave. And the lawyer says, absolutely. And they sign it, and that contract is invalidated by a court like this. So being aggressive and overly kind of
Restrictive.
restrictive
Yeah.
is not always the path forward. The right path is to balance these rights in light of the most current case law.
Yeah.
That takes both skill, but it also takes time. because you can get anything off the shelf. Anyone can literally Google an agreement, non-compete agreement. You get a sample, you pay $39.95 to one of those companies. You
Right.
download it and you go, hey, look at this, save 10 grand with a lawyer. Well, you may have saved 10 grand, but then bought yourself $1 million problem down the line.
Right. Absolutely. Okay, so let's go back to the kind of the most stereotypical, I think the word you used even was maybe nefarious example where okay, there's residuals, they've been stopped and the upstream partner is kind of just waiting to see what happens and seeing if they're going to be able to just keep this money. As the attorney for an ISO that finds themselves in that situation that's looking to fight back, give a little context like what would you do as the attorney? What would kind of your advice be to that ISO?
Well, we'd obviously evaluate, first of all, the referral agreement. That would be the starting point. Then whatever additional facts, and there are always some nuances. A lot of times it won't be as black and white. Someone will not simply call the ISO and say, look, thanks for all the referrals, but want to buy another sports car, so I think I'll just be holding on to the money that we're going to pay you. So we'd look at that. Most of the time, we'd probably make a demand to the upstream partner, explain our client's position, and ask for resolution. And if that doesn't work, then a lawsuit or an arbitration typically follows.
Sure.
I'm happy to take diplomatic paths forward. A lot of times, disputes are never, I don't want to say never, but they're seldom completely black and white, especially in business.
Sure.
In another field of life, someone could be crossing the street on a green light, drunk driver hits him. It's pretty black and white. In business, people always have arguments. Well, this person said they were going to do this, but they didn't do that, but they did this. And,
Yeah.
So we are always open to hearing the other side's position.
Okay.
Even if we don't agree with it. So that's why the initial
Right.
overture is typically an informal one. But there are times when it makes sense to just file a lawsuit. And there are a lot of reasons, strategic reasons for why that sometimes makes more sense than engaging in discussions. Now, mind you, discussions can be had at any stage of the proceeding, whether before litigation, during litigation, mid-trial, post-trial, during the appeal. I mean, it happens all the time.
Right.
So for our part, we're always open to listening. But at the same time, there is some consideration given to, when do we listen? When do we advance forward? When do we pace ourselves? And
so this next question is probably impossible to answer actually, but I'd love to get a couple of examples if you could. It's such a broad question, but as somebody who litigates these types of things a lot and ends up going to court for things and trying to get the money back for these ISOs due to upstream partners, being less than honest and transparent with them. Could you give us just a couple of tips of like, what are your main hot button things of preventative to say to the ISOs out there, like, probably want to make sure your agreement at least has this, or is there anything that really jumps out at you? I know there's a million things, but any maybe 2 or 3 things that just kind of stand out to you as the big ones that ISOs need to be aware of?
good question. Thinking about it, you know what? I would take even a step back because you're addressing the agreement. And I would just start with, look, not everyone's in a position to do this, but I would say, think of who you're doing business with. Because the truth is, there are people that have made it business practice to breach contracts. They've determined that, they're well represented and they can out litigate someone, just basically where the cost of a breach and the lawsuit is still to them less than what they would pay out. So to me, that's the first point. I mean, don't do business with someone who is absolutely known for being a thief. And I'm not talking about necessarily a person, but maybe a company. And so sometimes, you're getting a deal where you look at it and you go, wow, these are amazing terms. Well, they're amazing to get you in the door. And then these terms are going to change, or you might be cheated, or something else might happen. So, I mean, there are lawyers around who can correct a problem, but I think the better course from the outset, if you can manage it, would be to try and avoid it altogether. Maybe write your business to someone that's not known for stealing ISO's reserves. However, If you have no such information on a particular partner and everyone's acting what would seem to be in good faith, particular provisions to prevent this kind of thing. Look, you want to have robust reporting requirements. You want to make sure that when the merchants are sold or when the portfolio is sold, then the obligation to pay the ISO follows the sale. And that has to be mandatory, because
Right.
otherwise, they sell the portfolio and you go, well, all my merchants are still there. And they go, well, yeah, but your deal was with us and now the portfolio is with them. So that's, I think, critical. And this goes to just not a situation where someone's looking to undermine ISO's rights, but rather that's just a business transaction that was had. So I think that part's critical. Other considerations would be to look at whether or not the upstream partner is trying to restrict their potential liability via contractual means. A lot of times that won't work, especially if it's part of a calibrated effort to steal someone's funds. But those would be the considerations. Look, someone trying to do business with an upstream partner, trying to do large business potentially,
Right.
have someone look at your contract.
Yeah.
Have someone look at it, because a lot of times in these agreements, you look at them and you read them, and there's nothing offensive there.
Mhm.
But the reason for why they might be inadequate is not because of what's in them, but rather what's missing. The
Mhm.
additional rights that an ISO should negotiate for itself that are simply not apparent in the agreement. So someone who's not trained or just experienced in looking at them will look at a contract and everything seems even-handed. You've got the residual split, you've got the term, you've got all the typical things, and you go, this looks fine.
Yeah.
But there might be certain catches, and obviously the upstream partner in the typical scenario would be more experienced in negotiating these deals. So
Right.
they probably will try and leverage some of that experience to secure a deal that's more favorable to them. That's just business. By the way, I don't mean to cast aspersions at companies trying to secure the best deal for themselves that they can. That's how
Right.
business works. I'm
Right.
actually a strong proponent of it.
Right.
My only point is, don't do it in a way that's sneaky and surreptitious, and
Yeah.
a lot of times just plainly not just wrong, but violative of
Right.
either legal concepts or the plain contractual terms.
Yeah. So while you were talking about this, I had one other thing I was going to throw out there, and since I keep putting you on the spot today, I'm just going to continue in this line because I think it's interesting to get your thoughts. One of the other really common ones I've seen along these lines is where a company, an upstream partner, will they're paying an ISO, right? And an ISO will reach out to us, especially because we have the statement analysis business, and they'll say, hey, my residuals just don't add up, so when we'll do a statement analysis, we'll project, hey, this account should generate 7,000 a month in residual, and it'll generate 3,000. And what will happen in these cases is that the upstream partner will provide them with this reporting that's just incomplete, and it just doesn't show. And they'll just say, "Well, here's your cost." And I was like, "Well, how does this come up?" So I'm in these. This is very, very common actually in our industry. I'm just curious how you would approach a situation where there's some kind of evidence that this account should be paying out a larger margin, but it's really a sticky situation because we're dependent on the upstream partner to get the data to prove it. How would you approach a situation like that, where there's just a lot of money missing that seems like it's missing, but we just don't have the rock solid evidence because we don't have the data for it?
Well, that's an interesting question, and I'll tell you why. I mean, look, for our part, whenever we make these informal overtures to the person opposite of our client,
Right.
it's always initially polite because, look, there are a lot of factors that go into payment processing, and
Sure.
like I said, sometimes the scenario pitched by a client is different, and not deliberately different.
Right.
It's just different from what actually is happening.
Right. Different perceptions. Yeah.
Correct. So we typically make a polite overture. Now, the wrinkle there is if money is just not being shown, and if these statements are incomplete, but were complete maybe before, well, to me, that would reflect that someone is trying to see whether or not they can pull a fast one.
Right.
So again, we'll still be polite. We still make the diplomatic overture to try and ascertain the facts. But, once we start getting the pushback, or when the emails are not being responded to, or when the response is not to the question that we asked, but to something else, well, that's usually a red flag.
Right.
And then, depending on what's at stake and, how we feel about the case, we may escalate things. Look, and that's where the judicial system exists, right? If you just keep emailing someone for more info and they tell you either ignore you or just don't respond, a lawsuit is a really effective way of getting the answers they need.
I love it. And that's perfect for my next question because, for a lot of ISOs that maybe haven't gone quite that far, they've had situations, maybe they've had even an attorney involved, but they've been able to settle things kind of out of court. What would you say to the ISO that realizes like, wow, I wasn't able to get anywhere in this process, and everything, but they're scared about like actually taking someone to court and really, going that far with it. What would you say to them? What's that process like? What should they kind of expect from that?
Well, largely depends. No two lawsuits are the same. Um, a lot of times agreements provide for arbitration, and arbitration, for those who don't know what that is, it's basically a private trial instead of being in your local courthouse. You have a private judge. Usually it's a person, most of the time a retired judge who now just works privately and serves as your private hired judge, an impartial one.
Mm.
And you just pay him by the hour. Things there go a little quicker. Rules of evidence are a little more lax. Arbitrations are great. They move along. You're not tied into the court schedule. You're tied into whatever schedule you and the opposing party agree upon, or whatever the judge says. But it's never going to be 3 or 4 years out. That would be a very unique case, maybe a large antitrust or class action. But an arbitration usually would be done within a year and a half. Civil litigation, sometimes it could be more expensive than an arbitration, sometimes less. In civil case, you don't have to pay the judge, but sometimes the pleading rules make things unnecessarily more expensive. But that could take more time. But a lot of times you can, once discovery starts, and discovery is the process of exchanging information, once you actually collect the information that you need and it's clear that maybe a client has been cheated, that usually serves to lubricate the prospects for informal resolution. There are also mid litigation tools that can be used. For example, there are remedies that the law provides where if the claim is strong, it's based on the contract, it's clear that you're going to win. A court may issue something like a writ of attachment, it's called, but it's an order saying, look, I see that the plaintiff, even though they're not at trial, they're going to prevail here. So you, the defendant, you, the upstream partner, take the money that I've identified and put it into the plaintiff's hands. It usually goes to a sheriff. The sheriff holds it. But again, if such a ruling is issued, if the court finds early on that the plaintiff is likely going to win and orders such relief, then it typically leaves very little to fight about.
Interesting. Wow. Well, this has been very, very insightful. I think I could keep throwing these scenarios at you for the next couple of hours, but rather than doing that, for those who have their own scenario, maybe it's one that we discussed today, maybe it's a different one, and they want to get in contact with you to see if there's something to be done in these situations, where would you send them to connect with you and learn more?
Sure. I'll take a look at our website and see if what you have falls into our practice areas. I'll say that if it's payments related, it does.
Right.
But you can email me at erome@romellp.com. So it's EROME, Rome like the city, at romellp.com, ROMELLP.com. And you can call us at 310-282-0690.
Awesome. Eugene, thanks so much for your time. Always appreciate your expertise. Hey, everybody. I'm here with Vlad Sadovsky, CEO of Nativia, which is also the sponsor of this podcast. And he's got another exciting announcement for us today. What do you got for us, Vlad?
Well, James, today is a very exciting day. The other week we announced our Game On promotion.
Yes.
And the response response was just simply overwhelming. And one of the responses was that we have people that want to sign up in groups. So
Okay.
today we've made an adjustment, and it's now Nativia/Game On/teams. You can compete in teams. You know, there's Olympics coming up, so we felt that team competition is a good sport. And we have special team prizes separate and above from the prizes we have for individual performance. And those team prizes are obviously going to be spectacular.
And
A
maybe
lot of
for those who
sports.
for those who didn't listen to the announcement we just did, the last one, can you give a little more context of like the Game On thing of like how, you know, what it is and how they earn points and some of that kind of high level stuff?
Yeah, so to earn points on Game On is three things. Number one, show up at our events on every regional show. Number two, spend on the card, on the Nativia card, whether it's a personal or business, which we'll be rolling out at the nearest Northeast Acquirers event next week. And number three is get on our email list and get the special bonus points announcements of tasks to do, which I cannot announce, that will be announced later. Those are three ways you can earn points and obviously be entered into the leaders competition and win the prizes. It's not a drawing, it's not a raffle, it's an actual competition.
Wow, that's really cool. And then I also want to mention here, NEAA. So you said about it next week, April 3rd, right, is the after party that you have for the NEAA. And this is the Nativia beer pong contest is going to be hosted there, right? So any other details that you want to share about that one, Vlad?
Well, we started NEA last year with a ping pong party, as you remember, James.
I remember I was there.
So we wanted to we wanted to stay within the theme, and the closest we were able to come to is the beer factory. So lots of beer and lots of pong.
There you go. And this is at the Druthers Brewery in Albany. And again, that is on April 3rd there, the Nativia after party. So really
Yep.
cool stuff. So Patty, in the next few questions from the field, I want to be talking about how to overcome common objections, but I'm going to be using verticalized software as the kind of rebuttal to that. So I'm going to talk about kind of how I've changed my perception of overcoming some of the most common objections. And today we're going to talk about overcoming the objection, very, very common now for agents out in the field, which is I already have dual pricing or cash discounting or surcharging, and or you know, they might say, well, I'm not interested in that. You know, it's going to create a negative customer experience. So kind of these objections around dual pricing, right?
Okay.
Most salespeople today, that's what they are, you know, selling. They're selling some kind of dual pricing out in the field. And so, you know, in the past, you know, it was very simple. You go in, hey, I'm going to save you a bunch of money. I'm going to eliminate
Mhm.
your payment processing fees, and people would move forward. The challenge for many agents today is in their market now, everybody either already has the dual pricing if they're interested in it, or
Mhm.
they don't want it.
Right.
Right. And so that's kind of where dual pricing is at in a lot of markets today. So it's getting a little more challenging, right, to sell that. Now, there's some natural kind of inertia here where as more and more people adopt dual pricing, the people who initially were resistant are now like, okay, we'll give it a shot.
Right.
Right.
Sure.
But at
Sure.
the same time, we're getting a lot of these objections. So how do we overcome that? Well, I'll kind of break this down for you. And again, we're using vertical specific solutions. So again, now I'm going to a business and I have a vertical specific software solution that is for
Mhm.
their business that's going to help them. Let me show you kind of how that changes the objection. So if they say, well, we already have dual pricing, right?
Right.
Well, in most, I would say in probably 85% of the cases, that dual pricing is running through a standalone terminal because that's just
Sure.
how it's been
Because
sold.
that's how it was sold in the beginning anyway.
Right. There was no integration or whatever. So
Right.
the idea being now you have a vertical specific software that has dual pricing. So now what I would say to that merchant is I'd say, well, that's great. First of all, I congratulate you on jumping into that trend early. Now it's just so common, right? So good job in doing that. There's two concerns I'll tell you about. Number one, there was early on, it was like, well, the only way to do this program is to have kind of this side terminal that's not integrated. The good news is today you can actually have your cake and eat it too. So our program is the same. I'm not going to tell you our program is magically better in some way in terms of cost. except that our program is fully integrated into XYZ software that was
Right.
tailor-made for your business, which provides solutions like X, Y, and Z to help you
Right.
grow and remain efficient. However, there is one other really important thing, and that is Visa has really declared war on this idea of differential pricing. Obviously, Visa doesn't love the fact that you're charging people more money when they use a card.
Right.
So, in order to be fully compliant, you really do need a system now, Mr. Merchant or Miss Merchant, that is going to show and display these two prices side by side. And the good news is that because this is a software solution, not just a receipt, we are really able to give your customers a better experience and a more compliant solution, an experience, because it actually is going to display both prices, right? So
Right.
with
Right.
that in
Right.
mind, the next step would be for us to do a demo, because I want to make sure that you understand all the features and that it's the right fit for your business. So what would be the best day and time for you to do that? Tomorrow at 2 o'clock, or should I stop by Friday morning, which would work better for you?
Right.
So
Right.
you can
Which
see
is actually, so it's the same pitch. It's just different particulars. It's like
yeah.
the middle piece is different.
Yes, and so because you have that vertical specific software, we're able to
Right.
go a different direction. Because without that, Patty, the what we're seeing in the market now is already we're seeing the agents cannibalizing the industry. So now it's, oh well,
Right.
you're passing 3.99%. I can do 3.5.
I'm going
I
to
can
give you
do 2.25.
2.99.
Exactly.
Yeah.
And so now it's like, really? Is that really what you want to do? Versus saying, great job doing that at 399. I do the same thing, but we do it with software. That's a much, much better pitch for them. So you have that one. Again, you have these other objections, right? That'll come up where they'll say, well, what about, this customer experience? And it's like, well, I can understand why that was a concern for you, Miss Merchant, with the standalone terminal, because the truth of the matter is, yeah, they probably were a little confused when they came in and
Sure.
didn't really see the sign, and they get up to the counter and, but with our solution, it does X, Y, and Z. And so what you have to understand is with vertical specific software, we have the ability to programmatically, implement differential pricing in a way that's compliant, in a way that's customer centric. There's a lot of ISVs now out there, several already, who are printing labels as part of their solution suite for like a retail. Very soon, I think there was one I heard of, but I think there's going to be a lot more coming down the line that are going to print menus.
I've heard of that as well, right?
Yeah, so you can reprint them. So all of those things, it's like, okay, you got to bring this compliance to them, and we'll talk about it in another insider's report coming up. But I mean, Visa, they're not joking around, and there'll be some really interesting things coming out in the next 6 months that Visa's doing that are very interesting. I actually reached out directly to them about doing a podcast interview about these changes, and we'll see if they acquiesce. But
I'm glad you did that, because I could not get very far with them at all. I was hoping maybe you could get a little further.
yeah. So I have a connection that would be definitely the right person to have on the podcast, and we'll see if that comes to fruition. But at the end of the day, there are big changes happening, and with dual pricing, you need to use these vertical specific solutions, because
Right.
it doesn't take you out of scope in terms of compliance, but what it does is it actually gives you the tools to provide the customer experience that Visa wants you to provide in the first place. So I think that's really crucial. So anyway, so there's the first one. Any objections around dual pricing, differential pricing? Use vertical specific solutions to rebuttal those objections and maintain your margin at the same time.
Excellent advice. Thanks, James. So, James, I want to kind of continue on the theme of Visa here, because I came upon a factoid this week that should be part of any discussion of card fees in my mind. And that is that Visa is investing billions of dollars in cybersecurity, both to defend its own payment system and to develop services for its clients. This, according to CEO Ryan McInerney, during a recent investor conference. And the company expects to spend billions more. Here's the thing that really blew my mind. Visa has about 1,000 employees that are working on cybersecurity alone.
Wow. Goodness.
That's a lot of people.
That's a lot of payroll.
A lot of payroll. Can you imagine how big the payroll must be otherwise? I mean, if that's just one area, right?
Right.
He said the company fends off about $500 million attacks on its perimeter on a monthly basis, ranging from average phishing emails to sophisticated nation-state-backed cyber assaults. This was a RBC Capital Markets conference. He also noted that the company blocks about 20 million malicious emails every month that target its employees. Quote, we spent billions of dollars, we'll spend billions of dollars more protecting the network of networks that we built on behalf of our clients in the ecosystem. He added that Visa is also, quote, increasingly productizing, I guess that's the
Yeah,
proper word.
productizing, yes, yes.
Productizing, yes. It's cyber know-how to sell both additional network services and consulting services to customers.
Right.
We're all in an arms race to protect this ecosystem, to protect the network, he said.
Hmm.
I thought that was really very interesting,
Yeah.
James. I mean, that's
Yeah.
a lot of cybersecurity to have to put up, and it's also a lot of assaults on the system to be successfully batting away.
Well, it sounds like the best thing to do in an ecosystem like that would be to have some government regulation that forces them to allow a third network
Don't
to
you
have
think?
access.
Yeah, bring somebody else in that hasn't invested all that money, and then
yes.
let the poor consumer choose which one
Right, right.
they're going to use.
Right. Yeah. This is one area where I'm 1,000% on Visa's side in that,
You and
yes,
me
they,
both.
they have done a fantastic job. There's no denying it. The Visa network, knocking on wood here, the
Right?
Visa network has really done a fantastic job in terms of uptime, security, fraud prevention. And these are all critical components of the payments ecosystem that I, for one, would like to see stay intact.
Yes, and I think it's something that doesn't get a whole lot of airtime
Right.
around
Right.
debates around pricing. So
Yeah.
let's do our best to keep it out there.
Yeah. Good stuff. Thanks, Patty.
Mhm.